Yeah, thank you, Dave. Yeah, like you said, my presentation is on an overview of wildlife legislation in Alberta. Um, I'll start off just a note. I left the logos on here. My comments are my own entirely. Um, Also, there will definitely be some duplication in what I'm about to say, as in what was already said this morning and probably tomorrow as well. My goal here is to provide some overview and context for the panel today. So briefly, what I'm going over is a multi-jurisdictional framework over wildlife in Alberta. There's international, federal, provincial, and municipal elements involved. I'll be looking over traditional mechanisms, common provisions regarding habitat protection and species at risk, and then just emerging role of regional planning and commitments to biodiversity that will have some impact on wildlife management. So just some context again, jurisdiction over wildlife. Constitutionally, it's not expressly contemplated in the Constitution Act 1867. Traditionally, there's a relationship between land ownership and the right to harvest wildlife. So wildlife has been thought to be included under sections 9113 for property and civil rights, section 9116, matters of a local or private nature in the province, section 109, all lands, mines, minerals, and royalties in the province, and that's all then falls under provincial jurisdiction. Wildlife also falling under federal jurisdiction as well. For example, migratory birds, international trade and commerce, interjurisdictional wildlife fisheries, and wildlife management on federal lands. In addition, there are areas of concurrent federal and provincial jurisdiction. There's therefore a great need for interjurisdictional cooperation. It's been mentioned before. So John Donaghy of Searle in around 2000, he's in a panel tomorrow, and I don't know if he's here today, but he set out these 3 stages of eras of wildlife approaches to wildlife management. First one from Confederation to the 60s, game management era, 60s to the 80s, wildlife management era, 80s to 2000, which was the time of his paper, sustainable wildlife management era. And those approaches are reflected in the evolution of statutes across the country accordingly. Sorry. So around 2006, I'm going to cite at length this paper by Monique Paslak-Ross, who is associated with the Searle Canadian Institute for Resources Law. She did a comprehensive cross-country look at all the wildlife statutes in Canada and found some commonalities. So here are some of those typical elements of wildlife legislation and traditional management. First off, there's the administration section, which empowers a minister responsible, often an advisory board, a committee, and wildlife or conservation officers. Next is the establishment of property rights in wildlife. As a general rule, the Crown owns the property rights in wildlife, and then ownership is transferred if an animal is lawfully killed. Licensing provisions, as a general rule again, hunting requires an appropriate license, sets out fees, conditions, limitations, and an element of discretion on the minister's part. Rules for hunting. This relates to animals, season, time, territory, and the manner of hunting. Section regarding possession, use, and sale of wildlife, and this involves general prohibitions. Just general prohibitions in that regard. A section on prohibitions that usually relates to hunting without a license, outside season, relating to harassing and disturbing wildlife or their habitat, respect for trap lines, those kind of things. Enforcement section, wildlife officers generally have the powers of peace officers. Offenses and penalties, and discussion was of offenses under the legislation as summary convention offenses. There's discussion of sentencing, including fines, imprisonment, creative sentencing, loss and restrictions to licensing. And then the last bits common among these wildlife statutes is the regulations, which tend to be quite extensive, that build on or expand on the other matters already discussed. So, still going through this cross-country look are provisions regarding land-based management, seen as a very effective tool for conservation. Wildlife survival ultimately depends on this habitat. 2 ways that it can be put into place, either by general protection for the animal's abode, residence, habitat itself, or by designation of protected areas. And then continuing on, again, the cross-country look, the species at risk elements. There is, of course, the Federal Species at Risk Act, stemming largely from the UN Convention on Biological Diversity. Provinces as well often have species at risk provisions, either in standalone legislation or provisions within their wildlife statutes. Again, here's some common elements of that. Definitions, establishment of a committee or commission, designation process, species protection measures, and that generally relates to hunting, killing, possession, disturbance, selling. Habitat protection relates to destruction of habitat or setting up aside protected areas. Penal provisions can regard fines or imprisonment that can vary across jurisdictions. Recovery plans for designated species, and that's more variable across jurisdictions as well. And then relation to conformity with SARA, or the Accord for Protection of Species at Risk. And there's a note that SARA can prevail if provincial law and policy are inadequate. There's more variation among provinces in this subject. So that's sort of the cross-country look at traditional wildlife management mechanisms, common elements of wildlife statutes. I'm going back to the sort of landscape over Alberta, and here's some duplication is the international components that prevail. These are not meant to be exhaustive as well, I should note, but to the big ones, the UN Convention on Biological Diversity and CITES we've been hearing about. Federal level, got the Canadian Biodiversity Strategy, the WAPREDA, and of course SARA, among other federal legislation. Provincial, as I said earlier, wildlife management is largely under provincial jurisdiction. In Alberta, particularly, the Wildlife Act is really the large piece of legislation that governs. It's not primarily a habitat-based statute, but it involves some habitat-based provisions as well as matters about protected areas and species at risk. Environmental Protection Enhancement Act, EPIA, also generally governs related matters. It's a policy document, the strategy for the management of species at risk. Province-wide biodiversity policy have been under consultation in 2015. There's none finished that I'm aware of. And then, as we discussed with the sort of evolution of approaches to wildlife management, there's more of a shift to land-based management, and that does support some other emerging factors in Alberta, which are land use planning and biodiversity commitments. And I wanted to just talk a bit about land use planning. Starting in 2008, Alberta has started this innovative, comprehensive approach to land use planning through the Land Use Framework, and is implementing legislation, the Land Stewardship Act. Drivers are to manage population growth and cumulative effects in the region. The idea is to divide the province into 7 regions based generally on river basins, and create a regional plan and sub-regional plans for each one. There are 2 that are finished, and the third is underway. So we're still fairly on in the process. The 2 regional plans that are complete have sub-regional plans kind of in development. They aren't all complete as well. More specifically, for the purpose of this conversation, there is extensive discussion about biodiversity matters in the regional plans that are already completed. That's the Lower Athabasca and the South Saskatchewan. For those who are not totally familiar, the Lower Athabasca includes the oil sands mine region, and the South Saskatchewan is the bottom one that includes Alberta. It's the most dense population region in the province. Sub-regional plans include biodiversity management frameworks, or WIL. They're under development for both of the ones that are done. I believe there's one supposed to be being developed for the next one as well. Objectives within the biodiversity management framework include biodiversity, ecosystems, species at risk, and habitat provisions. So, as a general overall landscape, looking at biodiversity and wildlife management, habitat-based issues, I think this comes into play. I also wanted to mention that under this new framework, there involves some new tools for private land, and that includes some stewardship incentives that the other panelists are going to be talking about a bit more. I wanted to mention this, the draft Provincial Woodland Caribou Range Plan, because I just thought it was interesting. The woodland caribou is considered threatened under federal and provincial legislation, subject of recovery plans at both levels. Alberta released this draft plan in 2017, and the part that struck my attention was that it is meant to be implemented as a sub-regional plan under the land use planning framework. specifically a main component of the LARP landscape management plan. If you look at this map, I tried to sort of line them up just to look at this scale. The geography involved. This red areas are boreal caribou range. So if it's meant to form a large component of the LARP landscape management plan, it should also be forming a large component of sub-regional plans in 3 other regions once those are completed eventually. I did want to talk about urban wildlife, which is it's growing in attention and appreciation, but not a lot is usually said about it. So municipalities, or say, the increase in urban awareness of it as populations grow and as cities' footprints also increase. There's also a recognition both of the impact that urbanization has on wildlife and biodiversity, as well as what impact wildlife and biodiversity have on us in terms of public health and that kind of thing. So municipalities, they will not have any powers that are not delegated specifically by the province. Obviously, we talked about the fish and wildlife people here this morning. They still have jurisdiction over wildlife in Calgary, but there is certain ways that municipalities can affect wildlife and biodiversity through law and policy, by law and policy, largely policy. So Edmonton and Calgary are by far the largest urban areas in the province. And they're both now signatory to this Durban Commitment, Local Governments for Biodiversity, which is a voluntary commitment. It's not a UN-type document, but it is now an international association that has been made. Municipalities can affect these wildlife habitat and specifically biodiversity, connectivity, etc., through municipal development plans, various policy matters, generally linked to biodiversity, urban connectivity corridors, pest management as well. There are a variety of also non-government organizations, community-based organizations that also play a role and have roles relating to public education, wildlife conflict, and that kind of thing, or coexistence. Then moving on, the recent changes to the Municipal Government Act should also have an effect in this area. There's an increase on regional planning, metropolitan regional planning, particularly in the Calgary and Edmonton regions. Edmonton is largely unchanged, but Calgary's metropolitan planning has been mandated in a different form. There's a current voluntary planning that's currently underway, but that's been changed very recently. It's under current regulation. See, there's also possibly a concurrent increase in powers regarding environmental management. That's yet to be seen, but I wanted to include it just for completeness. So this is an area there isn't a lot of legal or regulatory commentary, but it is, I think, quite interesting. It's increasingly, I'll say important, but increasingly noteworthy. And just to sort of illustrate there's significance from a habitat kind of perspective, I just threw in, I pulled these out from the Edmonton and Calgary metropolitan plans. This Calgary one, the constituting municipality, is going to be different under the new mandated version, but just it'll be less far west, but it'll include a couple additional ones. But just to get an idea of the geographic area, that there is actually some implication for larger implications on wildlife connectivity, habitat, and that the municipal policies and to some extent bylaws will have an effect on these matters. That's about it. I don't know if we're doing questions now. I think as a general summary, I just wanted to highlight that there's multi-jurisdictional governance of wildlife in Alberta, international components, federal, provincial, as well as some municipal roles, and that this emerging focus on regional planning, municipal regional planning, as well as biodiversity commitments will have some effect on wildlife management and land-based habitat, in addition to the wildlife management traditional statutes currently in place. Yeah, okay. Should I close this out or?
this is the, oh, okay. All right, let's get this guy up here. Here we go. Oops, that's not what I want. That looks like it. Thank you. Welcome. It's so good to see so many people here, and hello to all the people who are out there and on the web connection. So I'm going to talk about wildlife and habitat protection and management other than by wildlife laws per se, and talk about some roles for courts and some case law that has been rendered with respect to some of the things I'm talking about here. Well, that one doesn't change it. I'll just do, here you go. So my outline is I'm going to first talk about the limitations of wildlife laws regarding protecting and managing wildlife and habitats, and then talk about other than wildlife laws, and I'll tell you what that is in a minute. But first from looking at a common law perspective, and then a legislative perspective, and then talk about just some takeaways. So limitations of wildlife laws. Sarah went over I mean my fellow speaker here, not the Species at Risk Act, went over the main components of standard wildlife laws. And I mean by wildlife laws here, I mean laws that are called wildlife acts or wildlife conservation acts, or you have a name of some animal in them, migratory birds or fisheries. So they're specifically aimed at managing wildlife, fish or wildlife. Well, there are some limitations with respect to these statutes when it comes to if you're interested in protecting habitat or if you're interested in destroying it, because they're really such a small part of the overall picture when it comes to things that can impact habitat positively or negatively. The wildlife acts that every province and territory has, they mainly control or manage such things as hunting licenses, trapping licenses, maybe some wildlife reserves, and they only protect habitat in a very sort of minimal way. Most of them, there are a couple exceptions. So we're talking about nests of birds, direct habitat, and dens. And so it kind of governs this kind of thing, which is one of my favorite Gary Larson cartoons. And so it's this guy hiding behind a tree with a gun, and this very moose-like looking deer says, "He's trying to shoot me, all right. Do I know this guy? I gotta think." So it's the kind of they're the kind of laws that look at wildlife as resources. It's very, very utilitarian looking. But there are lots of limitations with wildlife laws, even if you go as far as looking at species at risk laws. We've heard a lot about species at risk laws today, but one of their main problems, although they can protect habitat in the long run, especially if it's on public land, it's a Provincial Species at Risk Act, or if it's on federal land for the Federal Species at Risk Act. One of their main limitations is that they don't really come into effect until a species is almost out of habitat and is kind of gasping on its last breath. So, I mean, that's one of the great limitations. They don't protect habitat of species generally, just those that are various degrees close to extinction. And the example I have here is the greater sage grouse, and it has been said to be the most endangered animal in Canada. It lives in southeastern Alberta and southwestern Saskatchewan and part of Manitoba, and it has only 7% of its historical habitat left, and it's one of the reasons why its habitat is being so it's taken from him is because of things that are governed under other laws than wildlife laws. Like, for example, conversion of sage grasslands to farmlands, or then conversion of farmlands to urban development, and oil and gas developments under energy statutes, and all kinds of other statutes are the implementation of those statutes are the ones that are taking away the sage grouse habitat. Now, there has been an emergency protection order under the federal legislation, and I understand the SARA, meaning the federal legislation this time, and I understand things have slightly improved, but still, it's very difficult to implement those kinds of environmental protection orders because, one, you're dealing with private property and people who might not want to make the kind of changes in their management of their land to protect sage grouse, or you're dealing with already licensed projects, and you're dealing with oil and gas industries, and it's just very difficult at that stage. It would be nicer or better if we could somehow protect habitat before it becomes, you have to have an environmental protection order. So what I'm going to talk about some of the ways that at common law and through statute law, wildlife can be protected and sometimes just impacted. These are only a few examples for common law. I'm going to talk about contracts and licenses, restrictive covenants and easements, and leases. So for contracts and licenses, they're different entities, but I'm lumping them together because the case I'm looking at concerns both of them. So contracts, as we probably all know here, are agreements between two or more parties where there are promises exchanged for some kind of valuable consideration. They have a term, so they only last as long as a term, and they're generally speaking personal, meaning they only apply to the parties who entered into them. Licenses are also personal, and in that meaning a person or a level of government can give a license to a person to do something like drive a car, or with respect to land, to go on land and to do something in the land, like do some improvements, maybe restore some habitat. But again, licenses are also personal. They only apply to the licensor and the licensee, and they have a term. One thing is neither licenses or contracts on their own don't run with the land, as they say in law, meaning that they only bind the parties to them, and if it pertains to land, if a license or a contract pertains to land, it won't bind a future purchaser of that land if it's a different person from the person who entered the contract or is a party to the license. And an important, and I think sad in its own way, case in point is Willman versus Ducks Unlimited Canada. Now we all know Ducks Unlimited Canada and how much it has done, really a considerable amount to protect habitat, wildlife habitat in Canada. And I think, maybe for resource purposes, for utilization, for hunting, but I think Ducks has moved beyond that myself, I think. I just have this quote from Ducks. Since 1938, we've completed more than 10,366 projects and conserved, restored, or positively influenced more than 158.8 million acres of habitat. Well, that just goes to show you that you really need other than wildlife laws if you're interested in protecting habitat. Because the ways that they've done this protection are through things like contracts and licenses, and sometimes through interests that run with land, like restrictive covenants and leases and things that I'll talk about in a minute, and conservation easements, which Dave will be talking about. So the case is, in the late 1970s, Ducks Unlimited entered into an agreement with 32 landowners in southwestern Manitoba because there was lots of flooding out there, and so Ducks was going to go in and help with the flooding by doing some improvements in a marsh area, but was also wanted to do improvements in the marsh area to enhance wildfowl habitat. And in fact, it spent $1 million doing this over many years. These were 30-year agreements, and Ducks Unlimited had filed caveats on the properties to protect their interest. Caveats are filed at the Land Titles Office, and what they do is they give notice of some kind of interest in land. Well, this particular property that was the subject of this case had turned over a couple of times, and the current owner was Willman. And Willman didn't like this caveat on his property and didn't think that he should be bound by this Ducks Unlimited agreement, so he sued to get the caveat removed and won. And the reason why he won is because Ducks did not have an interest in land at the time, or so the court said. That the agreement was personal only between those parties, and what it was a contract and a license to go on the property and to do something. And the court agreed, and the caveat was then removed from the property. I don't know if Ducks Unlimited tried to get some kind of compensation, which it might have been able to do under other legislation for all the money it spent. But it goes to show you that that contracts and licenses, can be really useful in protecting habitat, but if they're going to be enforceable, they have to be done very carefully, and even if you're tried dealing, as I know Ducks and lots of NGOs do, or conservation organizations do, they like to be very friendly and chummy with the landowners that they're dealing with, but that's still in law that might not hold up. Restrictive covenants and easements are our interest in land, and a restrictive covenant is an agreement between a grantor and a grantee where they have to have what's called a dominant tenement and a servient tenement, where restrictions put on the servient tenement must benefit somehow the dominant tenement. And easements are similar. At common law, you need a dominant tenement and a servient tenement, but instead of restricting the uses of land to benefit the dominant tenement, it's more of giving rights to the owner of the dominant tenement in order, because it benefits them in some way. Now, they have been used a lot to protect habitat over the years, and they have been modified by statute as well, which even makes it easier for that to happen. Like, for example, if there's adjoining habitat between a dominant and a servient tenement, and the owner of the the dominant tenement wants to make sure that remains viable habitat, the owner could enter into a restrictive covenant with the servient tenement not to, in a restrictive covenant, not to, carry on land management practices that would destroy that habitat or adversely affect it, and then also maybe have an easement to go on the property to do improvements or whatever. But I said there could be statutory modifications, and there have been in most provinces. I'm going to talk about a case that had where there was a statutory modification, and it was on Section 219 of the Land Titles Act in British Columbia, which said that you didn't need to have a dominant and a servient tenement for these kinds of arrangements, as if you were a municipality or a level of government or certain other entities. You could enter into an agreement with the landowner that would run with the land, could be positive or negative, and it specifically could be to protect wildlife habitat. So that's what this case concerns. So you all might know Windset Greenhouses Limited. There's a sort of a picture of it there because you might have gone to your local Safeway or Co-op and bought food from it because it's one of the largest greenhouse fruit and vegetable suppliers. I don't know in Canada, but certainly a very large one. And in the I can't remember the exact year, but when Windset was putting in its phases of development, it had to get a development permits from the city of Delta in British Columbia. And the city of Delta was going to put some zoning in effect so that when Windset was building these huge greenhouses, that there would be some protections for wildlife and then some other things as well. But there are all kinds of problems with the bylaw being debated and being settled and stuff. And so Delta said, well, instead of going by bylaw for now, for the time being, I know you want your development permits, Windset, so we'll enter into one of these Section 219 restrictive covenants and put in the wildlife habitat provisions in that restrictive covenant and also some other provisions. And so Windset, feeling that really had to get along that, he would enter into what it thought would be a temporary restrictive covenant until Delta got its bylaw together. Well, Delta said in due course, well, why should we mess with this bylaw if we can just rely on this Section 219 covenant? Windset did not like that and sued to have that, or made an application to the court to have that restrictive covenant removed, which could be done under the BC Law Property Act, and won. And this is, I think, a little bit scary to me because these restrictive covenants are not unlike conservation easements, which can also be removed from property for certain reasons under legislation. In this case, it was removed because Windset was argued that it was really involuntary, that it was an involuntary restrictive covenant, and that it was a condition of a permit, and that it was always intended to be temporary, and that time had run out, and the court agreed with that, and so it took that restrictive covenant off the property, but also pointing out the differences between a zoning law, which is temporary in time too, because it can always be changed, and a restrictive covenant, which could be in perpetuity. So again, there are, although these instruments could be really important in protecting habitat, if they're going to be enforceable, then they have to be they really have to be voluntary. There are cases from Strathcona County up near Edmonton as well, where that municipality was trying to sort of foist conservation easements in the development and subdivision process, and court said, maybe it's just the Development Appeal Board said that you can't do that. They have to be completely voluntary. Okay, so leases, again, are interests in land, though sometimes they have to be registered on title in order to be enforced as such. They're basically an agreement to occupy and possess land for a certain period of time. And they certainly can be used for, and have been used to protect habitat or to do restoration of habitat. The case I'm going to consider here is actually a tribunal decision. It's a tribunal decision of the Surface Rights Board. It's not your typical lease where you lease land in order to live there or to do habitat protection or something like that. In this case, it had to do with land that was owned by the Alberta Conservation Association, which is a major association nonprofit in Alberta, and also by the Alberta Fish and Game Association. Now, the ACA, which came into existence in the late 1990s has conserved, according to its website, I think 210,000 acres of land to restore it to wildlife habitat. And Alberta Fish and Game Association is also involved in those kinds of activities. And so they were the owners of this land, and their use of that land, the reason why they bought that land was to restore it, so to help out listed species, endangered or otherwise threatened species. Now, Hansen Drilling Ventures was an oil and gas company that was going to carry out operations on the land, and under Alberta law, they had to enter into a loss of use agreement with the ACA, and then ACA had to be compensated for its loss of use. Now, the company wanted to pay, I think, $2,000 or something for this loss of use, and the ACA and the Alberta Fish and Game Association didn't agree, so it went to the Alberta Surface Rights Board. Alberta Surface Rights Board looked at the situation, and I would have thought that would have been an odd situation. Usually it's loss of uses for agricultural purposes or something, really concrete that's easy to understand and perhaps quantify. But the ACA looked at it, the Surface Rights Boards looked at it. The ACA came there with market comparables, so there must be other organizations or maybe their own organization doing this at other places. And the Surface Rights Board agreed with the ACA. And one of the things I find pretty interesting about this is how there was, at least from the decision, maybe in the case itself, but I couldn't see any discussion of whether restoring land to a natural state to assist habitat, just to help restore habitat for listed species was a use of land. I think it is, but but I'm easy to convince in that way. But the Surface Rights Board didn't even seem to question that. What they were really looking for was what they wanted the market to determine what the compensation should be here. That discussion doesn't seem to have been had, or if it was, I didn't see it in the decision. Now I'm going to switch over to legislative other than wildlife laws, and just to talk about them first. We already talked about Wildlife Act, Species at Risk Act, and all those things. Now I'm going to talk about some other laws, and Sarah has talked about some of them, that I think are really important with respect to wildlife and habitat, for good or bad. But first, I just want to have a couple words on policies, because sometimes policies, it's not clear whether policies are law or not. Policies are also really, really important when it comes to habitat protection, because governments rely on them. They're easy, that you don't have to go through legislative debate on them. You can, pass them, maybe they could be ministerial, they could be cabinet, and they're really important in wildlife habitat protection and in how legislative provisions are going to be carried out. I just have a few examples here, a bunch of federal ones. One of the issues in the resident killer whale case that Dinah was talking about earlier today was whether the federal minister could rely on policies as protection, as legal protection for killer whales. And the federal court in that case said no, because policies, at least the policies they were looking at, were not legally binding. Now, policy can become legally binding if it's brought into law in one way or the other, and I think the only one I'm going to focus on here is the Alberta Wetland Policy. So this is a policy so that if a person wants to destroy a wetland, they have to go through there's a certain formula: avoid, minimize, and then compensate. And there are questions as to whether that's actually law. It's not part of any law. It was passed by cabinet. It's by cabinet order, so that makes it look a little law-like. But if you want to get a license under the Water Act or an approval under the Water Act to, say, drain a marsh, then part of your approval condition, one of your approval conditions will be compliance with the Alberta wetland policy, at which point it becomes law, at least for that proponent, because the Water Act says that you must comply with the conditions of your approvals or licenses. And we recently had an Environmental Appeal Board decision in Alberta that resulted in a ministerial order that said it's binding. So I think it's probably binding if it were actually challenged. I mean, binding on administrators who are administrating the Water Act. But I just wanted to say this about policies, because I'm focusing on other than wildlife laws, and policies can or may not be laws. Now, I just want to mention a few before I talk about environmental assessment, which I'll talk about for a couple of minutes, because they're so important. And Sarah has mentioned some of these already. Land use plans, Sarah talked about the Alberta Land Stewardship Act, and zoning, municipal zoning is just so important. If you have a real forward-looking, at least what I would call a forward-looking municipality like Strathcona County, you might try to do some wildlife habitat zoning and see how far that goes. And this example here is from the rural municipality of Enniskillen, and that's in Saskatchewan. And all of these oblongs, these greenish oblongs here, are zoned for wildlife habitat protection. And some are conveniently in riparian areas that might be very close to Crown-owned land anyway. But I think it's really interesting that, what that would mean, that there would be restrictions on what you can do to develop that land if you're a landowner, because you'll have to respect the fact that it's wildlife habitat. And then, of course, there's all of the, hundreds of statutes throughout Canada that designate land for protection, and Sarah mentioned some of those as well. Your national parks, your provincial parks, all levels of park. One of my favorites here is Moose Lake Provincial Park. You'll know that if you're from Edmonton. Another really important example are statutes that have enabled economic instruments like conservation easements that Dave will be talking about, and transfer of development credits, and I'll leave those to Dave. The only one I'm going to talk about for a couple minutes is environmental assessment legislation and consequent permitting. So environmental impact assessment is a process that's used to determine mainly the environmental impacts of a proposed project that has to be assessed under the provincial, territorial, or federal legislation. And then government will look at the impacts and then determine whether it should allow the project to proceed by giving it a permit usually under some other legislation, or not give a permit, or give the permit with conditions, and require mitigation for environmental impacts and so on. So that's what's called Project EA. I'm calling it IA here because impact assessment can sometimes be things other than environmental impact assessment. Now, there's obviously a connection between environmental assessment and wildlife habitat protection and management. Sometimes it's not so good for the environment, but I think it's always a very good exercise to get to have an environmental impact assessment if a project, like say a mining project, might destroy or impact wildlife habitat. What it at least does then is it requires that there be an assessment of what the habitat is, how far it extends, what plants and other things, salt licks or whatever, are there that the wildlife that are looking at that you're looking at depend on. Look at the larger picture, cumulative effects, and all this. So you get a whole lot of information about the wildlife there. It may disclose some species at risk, in which case that will raise other issues that have to be dealt with. It might result in planning a project differently to avoid harm to the wildlife or the habitat, or it could result in conditions, mitigation conditions, and the like. So that will be useful with respect to that habitat. So I think it's really preferable that projects be carried out with an environmental assessment. But whether a project will be or not depends upon the specific legislation, provincial, territorial, or federal. Another kind of impact assessment that's important with respect to wildlife and habitat management is strategic IA, and that strategic deals with plans, policies, and programs of a government. And so if a government is going to, say, come out with a climate change program or policy, they'll do an environmental impact assessment if required or desired, and then see what will be the consequences of having that, or an energy development program, or whatever. The regional impact assessment is also really key. Sarah mentioned the Alberta Land Stewardship Act. There were a lot of regional assessments done in connection with that and with the various regional plans under it. So there you're looking at a region of land, and you'd be identifying wildlife habitat and connective habitat and the like. And so you know where development is more preferable and where development should be avoided with respect to whatever species and habitat you're looking at. So after an environmental assessment is carried out, as I said, the government official who's making the decision on a project will look at the assessment and then determine whether it should go ahead. And so, like I said, some of the good things are it could lead to mitigation of adverse effects, maybe by enhancing habitat elsewhere, or minimization, avoiding effects, or through project conditions. It also could lead to monitoring to see if the conditions are actually working, follow-up, and adaptive management that might require a different kind of environmental management strategy on the part of the proponent if the predictions on the environmental habitat consequences of the project were wrong. So I think environmental impact assessment has a really big role overall in Canada with respect to wildlife habitat and wildlife protection. I just want to mention the new federal bill C-69, the Impact Assessment Act, which what's part of it, the bill, and because one thing it's going to do, if it's passed as such, is expand environmental assessment to social, economic, health, and environmental assessment. And so what is that going to mean for wildlife and habitat? I'm not sure, but if you had a listed project that was, say, for a project that's in a national park, and a national park, by its very purposes, under the Canada National Park Act, is to preserve ecological integrity, and you're going to be assessing it for social, environmental, economic, and health. I don't know, there seems to be a disconnect there. But we'll see how that goes. The act does not contain a whole lot of detail as to how that's going to pan out in the end. But that's being, it's in Parliament right now and has just gone to committee, or will be going to committee very soon. With respect to environmental assessment and the courts, I just have one example. There are, I don't know how many, hundreds of examples where environmental assessment has been looked at by the courts, and this is one I'm going to look at is George and Marchik. And the reason why I chose this case is because I think it demonstrates how environmental assessment can be important to habitat. So this is a case where this Huckleberry copper mining company wanted to develop an open pit copper mine in British Columbia, and it needed a permit under the mining legislation, provincial mining legislation, and an environmental assessment was carried out under that legislation. That was in, I think, around 1995. But kind of midstream, the British Columbia environmental assessment legislation was passed. And then they got their, Huckleberry got its permit under the mining legislation. Yeah, I see. I'm almost done. But then it was contested because they didn't consider impacts on wildlife and some other things. And the court agreed and said, look, you should have done a full environmental assessment under the new Environmental Assessment Act. So that's what was done. And as a result of that environmental assessment, the certificate, which was the permit under the mining legislation, was amended, and some conditions were put on, including to restore habitat on reclamation and to do all other restoration projects like this fish ladder here. And apparently there were no fish in this creek prior to this project, but now there are, and indeed, I don't want to make this story sound better than it is, but Huckleberry did win a couple awards for its environmental performance in this. So, if that environmental assessment hadn't come on board in the middle, it might have just been open pit mine, period. So my last slide, moral of the story, and that's protection and management of wildlife and habitat comprises a complex intermixture of laws and other tools and arrangements. I didn't talk about non-legal ones. There's all kinds of other stewardship and other ones out there. And that if you want to preserve and protect, I think you need to look at the entire puzzle and the pieces. I have Yellowstone to Yukon, which is this very cooperative venture to protect connective habitat from Yellowstone area all the way up to the Yukon, which is using or trying to piece together all kinds of tools, whether legislative, policy, stewardship, everything. And there is, I think, I've shown an important and consequential role of the courts. And it would be my hope that courts would also take the big look, not just look at the little piece, is this conservation easement valid, but also the really importance of that particular piece to the larger goals of wildlife and habitat protection. Thank you.
So, and lastly, I'll be bringing the session to a close, well, other than questions. I know it's late in the afternoon and it's probably still snowing out there, so I will try and be concise. I have to admit that when I was asked to speak to the matter of market-based instruments for conservation today, I found it rather an ironic request, precisely because the name of this series is Environment in the Courtroom, and we're focusing on enforcement. And it's the nature of MBIs, market-based instruments, to try and move our economic and environmental relations away from courtrooms and heavy reliance upon enforcement and move further upstream in the economic system in order to change our incentive structure to encourage environmentally beneficial behavior and discourage environmentally destructive behavior, and maybe in a fundamental way in which those the things that would ordinarily be subject of enforcement actually never even get considered. So I'm going to start by talking a little bit about the nature of MBIs and the variety of forms that they come in, and then briefly look at four types of instruments, three of which have received some judicial consideration. I'm going to suggest that these instruments, for the most part, are developed in the policy realm, often coming out of academia, including economics departments. They have not been firmly founded in many cases in the judicial system. And so what that means is that the role of the courts often is to look at a very, very small piece of a larger complex system. Even though some of those legal concepts that will come before the court may be important foundations for that larger system. And so I think it's a caution to those of us involved in the legal system to be aware that we may be looking at narrow legal points in some cases, but there may be a whole edifice of environmental regulation built upon that very narrow foundation. And I want to look at some of those cases where it may have had that implication. So there's two definitions here that I've pulled, one from academic literature and another from Alberta policy of MBIs. So the classic definition, Robert Stavins at Harvard is one of the granddaddies of this whole area of thought, and his definition years ago was that market-based instruments are regulations that encourage behavior through market signals rather than through explicit directives regarding pollution control or methods. Now, since he formulated that, it's been applied to a much greater range of environmental issues than pollution control regulation. But the important part here is that it is intended to encourage behavior through market signals, and I'll come back to the second component in a moment. Very much in common with that, the Alberta's Land Use Framework, which is our major land use policy from 2008, contains the definition that market-based instruments provide financial incentives and disincentives to guide behavior, facilitated through regulation, I'm skipping through this, and create a price mechanism to motivate behavior. So we want to make it more profitable, frankly, to engage in environmentally benevolent behavior and more costly to engage in environmentally destructive behavior. But it is important to note that in both these definitions, it's founded in regulation. So it's the concept is often contrasted, what's considered, referred to as the command and control model. That is what we usually think of as the legal system of explicit prescriptions and prohibitions guiding behavior. Instead, is intended to provide certain incentives. It's very much in keeping with the modern trend towards nudge-style policies and behavioral economics in order to allow people to voluntarily choose to engage in the right behavior, but providing some flexibility as to how they do that. Not as often discussed, the MBIs are contrasted very much, I think, and importantly, with a small school of thought that is often referred to as free market environmentalism. There is a school of thought which basically says that we do not need a lot of regulation in the area of environment. What we need to do is privatize as many elements of ecosystems as possible, and then allow economic forces to thrive, and the glories of the marketplace will result in conservation taking place. It's not a large school of thought, it's not popular, but it is out there, and from time to time people will confuse that very much libertarian approach to environmental regulation with MBIs, and I think that's wrong. I think that MBIs are susceptible to a certain amount of misinterpretation and also some underestimation. Whereas these definitions would appear to be fairly conservative in that we're making minor adjustments to incentive structures in contrast to the sort of large, dramatic, sweeping changes that can come from amended legislation and wholesale regulation. In fact, my suggestion is that MBIs have the potential, at least, to be quite radical and even at their extreme, quite subversive in the sense of what they are attempting to do in their most ambitious form is transform the nature of our economic relations. And in doing that, move our society very much towards a more sustainable model and away from the model that I might overly simplistically characterize that we have had, where our economic incentives drive many parts of society, perhaps all of us, to engage in behavior which is exploitive of our environment. But then as we near the last active parts of that process, we set up legal barriers with prohibitions and environmental assessments. Say, well, yeah, that may make perfect economic sense for you to do, and we understand why you want to do it, but we're not going to let you do it without you paying fines or going through these processes. Rather, we're going, as I say, upstream so that people don't even necessarily form the intention to do those things. That's our most ambitious and optimistic version of the MBI model. So the benefits that are claimed for MBIs is that they provide for flexibility of behavior. People can find their own ways to creatively reach environmentally benevolent ends. They are voluntary in the sense that they provide incentives, but people, if they wish to act contrary to those incentives for their own reasons, are free to do so, but the presumption is not that a minority of people will do that, and so the cumulative impact will be insignificant. There's lower administrative costs because every behavior does not have to be policed. There's an incentive to lower the cost of attaining objectives. Because of flexibility, people will look for innovation and and economically and personally efficient ways to pursue environmentally benevolent ends. I have to note, though, that these benefits are often claimed, especially by economists. There's less empirical evidence that they necessarily produce this, particularly in the many forms in which they come. And here's a list of some of the forms of which they do come or have been proposed. And I won't go through these one by one, but you'll note that there are a wide variety. And it has been noted that to some extent, MBI is actually a little bit of a misleading category, that in some cases, what these different tools have in common is very hard to determine. And probably what it really comes down to is that they either lend increased transparency to our existing market so that people can get a better sense of the economic or rather the environmental implications of their economic behavior, or on the other hand, they change the price incentive in order to change that behavior. I will be going through 4 of those instruments as we go in. But really, and with respect to the price incentive, that tends to take 2 pretty broad directions. One is new or enhanced liability for negative environmental impacts, increasing the cost of those impacts. And secondly is new security or value, and sometimes even property rights, in positive environmental impacts, increasing the profit incentive to engage in environmentally benevolent behavior. So the first one that I would like to look at, and Arlene mentioned this, is conservation easements. Conservation easements are a statutory interest in land whereby a landowner can restrict their use of the land to protect some environmental, aesthetic, or agricultural interest. They are distinct from common law easements in that they do not require a dominant tenement, as as Arlene said, but rather the easement is typically given up to a qualified third party, usually a government department, a municipality, or most commonly a nonprofit conservation group such as a land trust that is properly qualified to hold it. In some other jurisdictions, it's referred to as a conservation covenant or other name. As far as I know, I believe every jurisdiction in Canada has some provision for this, but you will find it in statute. It cannot be derived in common law. In Alberta, the statute is the Alberta Land Stewardship Act, and this is the applicable provision. I won't read it, but you'll see that an owner can place an easement on their land with a qualified organization for one of three purposes: protection, conservation, enhancement of the environment, protection, conservation, enhancement of scenic or aesthetic values, and protection, conservation, enhancement of agricultural land or land for agricultural purposes. Well, this received judicial consideration in this case of the Nature Conservancy and the Waterton Land Trust. This is, and I'll put this caveat on all of my descriptions of these cases. I'm looking at three cases here. Each one of them is actually quite complicated with a large number of issues, and I very much cherry-picked the single issue that I'm concerned with, and wouldn't want you to think that my simple comments are reflective of the simplicity of these cases. In this case, the landowner, the Waterton Land Trust, which is not a land trust, it was a private corporation and that owned a ranch, it purported to give a conservation easement to the Nature Conservancy of Canada, which is actually a land trust. And part of that easement was a variety of management measures, including that the landowner would not use wildlife-proof fences. The particular use that the land is put to is a bison ranch, so fencing is a major issue because bison don't tend to stay put very well without firm fences. There was some question as to whether or not the fences that were used by the Waterton Land Trust were, I'll just call it WLT because I find even the name is confusing as to who's who here. So the WLT put up fencing, which the Nature Conservancy held was not wildlife friendly or wildlife proof. The NCC brought a lawsuit to enforce the conservation easement. The WLT countersued for declaration that the easement was invalid. And there was a whole variety of arguments. As it turned out, the history of this easement, there had been a myriad of mistakes and typos and different versions crossing paths. And so it's a very long decision that considers a lot of contractual doctrines about rectification and mistake. And it is a mess. And it's a great law school exam. But as a very specific point in here, the landowner argued that the Nature Conservancy, the plaintiff, had failed to establish, and they suggested that expert evidence was required, that the provisions of the easement would actually accomplish an environmental purpose, and therefore that those provisions of, those provisions of the Land Stewardship Act had not been complied with, and that the easement was therefore not legal. Well, I'm happy to say that the Court of Queen's Bench made rather short shrift of that argument in their long decision. And I won't read again the whole provision, but basically said, I disagree with what amounts to a presumption of invalidity. I disagree that a priori conservation easement is unenforceable unless the grantee demonstrates with scientific evidence that the conservation easement or the specified term accomplishes at least one of the statutory purposes. On the face of an easement, it would be apparent that the grantor's purpose fall within at least one of the statutory purposes. So I think there was potential in this case if the court had been a little bit I don't want to use overly judgmental language here, but if the court hadn't been quite as savvy as what they were being faced with, was the potential here to seriously undermine the effectiveness of the conservation easement legislation. If they had bought the argument that you have to provide evidence that your easement is not only has a particular purpose, but it is actually serving that purpose in a scientifically demonstrable way, that would have been such a huge encumbrance on the use of conservation easements and their enforcement that it would have greatly diminished their utility in environmental protection. So, shifting to the second tool here, trade of development credits, which again Arlene briefly mentioned. This is a municipal planning tool for shifting development pressures. And what it does is it assigns development rights to all lands throughout a municipality, but designates certain areas as having high conservation interest, which, and then others as areas of low conservation interest. And it allows a developer who wishes to increase the density of development, which is a way of making development profitable, to purchase the development rights in the high conservation interest areas, which are referred to as sending parcels, and move those development rights to the receiving parcels, which are the low conservation interest, thereby moving development rights around the landscape in order to meet the land use planning objectives of the municipality. And it's a tool that's been used many places in the United States. It's been experimented with here, but many of us feel that it has a lot of potential for land use planning. And one of the benefits is that it means that those landowners who own land in areas of high conservation interest have a way of receiving payment for their rights, not so that those lands will be developed, but rather so those rights can be transferred to other areas. So it keeps people from being frozen out of the benefits of development. Now, it is not referred to in the Alberta's Municipal Government Act, even though it is a municipal planning tool. And it is enabled, again, by the Alberta Land Stewardship Act, which was passed in 2009. But the provision in ALSA, as it's called, says that any TDC scheme must be approved by the Lieutenant Governor in Council. So that takes us to our second case, which is that of Mr. Keller and the Municipal District of Bighorn, just west of Calgary here. Keller, the case, or prior to ALSA being brought in 2010, the municipality created its own TDC scheme to enable specific development. Mr. Keller was a neighboring landowner, and he litigated to stop the implementation of the TDC. And one of his arguments was that, actually two different arguments related. One was that the TDC scheme was not provided for under the Municipal Government Act. Madam Justice Hunt MacDonald basically said that the provisions of the MGA that provided for the planning of development density and for environmental planning were sufficient to enable a TDC scheme, that it was not necessary to have explicit reference to it in the MGA. And then secondly, Mr. Keller argued that the TDC scheme was not approved by the Lieutenant Governor and Council by such that it was contrary to ALSA, which was in force by the time the case went to trial. Well, and again, her ladyship said, well, in this case, you're referring to legislation which is subsequent to the events. The legislation is not retroactive and therefore has no application in this case, and she allowed the TDC scheme to stand. So again, I think both these arguments were fairly easy to make, but the court was receptive enough to the larger scheme and intent behind trade of development credits and what the MD was trying to do, that they did not fall into the trap that may have undermined not only this particular situation, but a larger innovative scheme for protection. Thirdly, and this is not as happy a story, As I said, one of the major thrusts in MBIs is to create new rights, sometimes property rights in environmental goods. The idea here is that by allowing those who create environmental benefits to retain the value of those benefits, avoid dissipating those benefits into the public, and therefore avoid what's called the tragedy of the commons. The private actor retains the benefit and is incented to carry on acting in an environmentally beneficial way. And secondly, if those benefits actually are tangible, transferable property rights, you can create a market in them, which then helps to create a profit motive behind environmental goods. So this is rather an odd case that Arlene was very much directly involved in. The Water Conservation Trust of Canada versus the Environmental Appeals Board. The Water Conservation Trust of Canada is the water trust that Arlene sits on the board of. It's the only one in Canada, the only water trust, and a nonprofit organization which exists in order to hold water rights for the purposes of benefiting and preserving aquatic ecosystems. Part of the relevant law for this case is found in Section 51 of Alberta's Water Act, and this deals with water licensing. Section 51(1), first of all, water is owned by the province, and all water must be obtained through licensing from the province. So Section 51(1) says that a license may be issued to any person for a wide range of issues that are listed in regulations, one of which includes implementing a water conservation objective. Water conservation objective is a defined term in the legislation. It basically refers to an officially recognized objective of maintaining a certain amount of water in stream for purposes of conservation. But an exception to Section 51(1) says that is not Section 51(2), that upon application by the government, the license may be issued to the government only for purposes of implementing a water conservation objective. So, in the Water Trust case, these provisions and the related definitions and so on were considered. Here's the fact situation. It's pretty simple. ConocoPhillips Canada owned a water license to access water out of stream as part of in the South Saskatchewan Basin in a particular location. Through their own efforts, they managed to conserve water in their operations and thereby free up some of that water for other use. Rather than apply it to other industrial uses, they decided, for philanthropic and probably for PR reasons, to donate that license to the Water Conservation Trust of Canada, which would appear to be a good news story. Water is a scarce resource. It's needed for aquatic conservation. We're now taking it out of an industrial use and applying it to conservation. That transfer, however, had to be approved by the Director of Alberta Environment, and he said no, he refused to consent to it. The Water Trust appealed that to the Environmental Appeals Board. The Environmental Appeals Board upheld the decision of the director. And then appeal was made to the Court of Queen's Bench, and the Court of Queen's Bench held that the EAB and the director had made a reasonable decision. And so as a result, this apparently thoroughly beneficial philanthropic act was frustrated. Now, there's a lot of issues of statutory interpretation, and it's much more complicated than I can get into here. But what I found disconcerting was this paraphrasing of Alberta Environment's position that was found in the EAB report, and which the court implicitly seemed to endorse. And this is that the director explained that the government is in the best position to consult with the public and weigh the opportunity and costs and broader implications of keeping water in stream as opposed to allocating it for other uses. Basically going on, the pretty clear intent here is that the government is in a much better position to decide whether or not water should be in stream or out of stream. And when private parties conserve water and leave it in stream, they are meddling in things that are none of their affair. And when we decide that water is to be used for an industrial use, it better be used for an industrial use. And Conoco, if you're going to retool your systems to conserve water, we want that water back so we can give it to Shell. And I know Arlene's giving me a really dirty look because we've been very, very careful to be very judicial about language on this. But this was really the upshot of this decision. And it's really disappointing that this is actually part of a larger water management regime where there's lots of talk about how we want to create market incentives and so on. But we had a whole line of authorities here that, to my mind, really missed a golden opportunity here to create some new form of valuable environmental property. Okay, I'm really running short on time here, and after having prompted Arlene to speed up, I better do it myself. Conservation offsets, my last topic here. This is essentially, I'll get right to it. It's the process whereby negative environmental impacts are compensated for by the intentional creation of environmental positives. And I can, and many of you will know this, I can talk for hours about it, but it is it's a policy tool which is getting increasing attention, and we're seeing it applied to a broad range of environmental media. The interesting point is, so we've seen it applied in federal policy. Almost every province has one offset regime or another, usually based on policy. More than legislation. The interesting thing here is that regulators have been, for several years, imposing offset conditions on different forms of development. And largely this has been federal regulators, because the federal policy on offsets has been much clearer than provincial policy. I'm happy, though, to announce, because this is the first time, other than the talk I gave this morning, where it's been talked about publicly. This is the last one here. Last Thursday, on February 22nd, the Alberta Energy Regulator, for the first time in their history, issued a statement that imposed offset conditions on caribou habitat. A pipeline by TransCanada Pipeline interfered with caribou habitat, and the regulator told them they have to provide replacement habitat through rehabilitation of seismic lines with a ratio of 2 to 1. And that's the first time the AER has taken that on, so more power to them. I hope that has many ripples. My point about all these conditions, though, however, is that offsetting is almost nowhere found in legislation or regulation. It is largely a result of regulators taking the initiative, sometimes backed by policy, sometimes not, as in the case of the AER, to impose these conditions, relying on their jurisdiction to impose conditions on developments. And what I find remarkable about this list is in none of these cases did it result in litigation, and we have a long history in those other areas, such as federal fisheries regime, where offsetting has been required as a matter of routine, and yet very, very rarely litigated. And I think, to get back to my original points about the nature of MBIs, that what they seek to do is get these incentives out of the courtroom, away from concerns of enforcement, rather get them early on in the planning of projects, upstream in the in considering the economics of our activities. I think this is starting to exhibit, admittedly these still involve regulators in the individual decisions, but they are not coming before the courts on a regular basis, and I think that's a very healthy thing. And that's it. And since it's a snowy Friday afternoon, I thought a nice sunny summer picture was in order. Thank you. So maybe we only have a couple of minutes in our time, but But for those of you that can stay, I think we can stay as well for a bit of a discussion. Nikki.
Hi, I had a question for Arlene. Whoa, this is loud. She mentioned the fact of being able to use land use zoning for municipalities to protect certain areas. I actually have a specific question. In an area structure plan, there's a key wildlife biodiversity zone identified, but it's privately owned land by developers. Is there a legal tool or legally binding tool to zone that as, say, urban nature?
I'm sorry, where are you speaking?
She's up in the back.
Oh, okay. That just helps. That kind of zoning has been done, yes. Is it challengeable? I'm not really sure. There are all kinds of, municipalities have very broad powers under their municipal legislation to zone. They can zone, say, this is industrial only, or this is residential only. Can they say this is wildlife habitat protection only? I don't know of any cases that have been successful in challenging that. The challenge would be, I have property rights somehow to zone this. To cut down all the trees. Let's say it's a wildlife habitat for migratory birds or something. But in other places on Earth, this would just be very standard. In Finland or a number of the Scandinavian countries, that kind of zoning is very common. I don't think that, at least last time I looked, municipalities haven't been really aggressive. Some more forward-looking municipalities have, like Strathcona County. Maybe someone has done more recent research than I and has examples of such zoning. No.
Nikki.
Hi. I just wanted to get, I guess, a legal perspective on how a directive is different from a guideline. Alberta Environment and Parks has recently been rolling out directives specific to certain industries, and so that's the context I'm coming from.
I actually did some research on that recently, if you don't mind, because I was concerned about directives coming from Environment and Parks, as in contrast to under the Alberta the AER, Energy Regulator, because under the regulator legislation, there is a provision that says that I think it's the minister with cabinet approval can pass directives, and then they're binding on administrators and anyone else who's governed by them. And so AER directives, if they're properly passed in accordance with that legislation, are legally binding. I have problems with the ones from Environment and Parks. I think the government has a perspective that they're binding on administrators, and if they're passed by with the approval of cabinet, then that makes them a little bit more like law. But I have not been able to locate a provision in the environmental legislation that's as strong and clear as in the energy legislation.
I think we have an online.
I have an online question. I have about three, but anyway. One of them is, would you mind expanding on permanency of conservation easements, particularly with reference to Alberta? How robust are they with respect to being removed from traveling with the land?
Do you want to take that? Oh, you can. So they are, first of all, there's nothing that requires them to be permanent. There's nothing in the legislation, although they typically are expected to be permanent. The real sources of vulnerability for them are that they can be removed by order of the responsible minister. And I'm just speaking off the top of my head, I'm not even sure the minister has to provide reasons. And secondly, they are open to court challenge, as we saw in the Waterton Trust case. And what I didn't say about that case was ultimately that easement was defeated because the court found that the phrase wildlife-proof fence was too vague in order to be sufficiently enforceable. So they're, like any other written agreement, they are open to challenge and perverse interpretations and so on. So even with the best of intentions, as it does pass from owner to owner with the land, it may be that some subsequent owner either is not interested in enforcing it or complying with it, or has a different interpretation of it, and may decide to roll up their sleeves and push the limits of it, or try to eliminate it altogether. Yes.
My question is for Arlene. How likely is it that an individual or an organization in the public can basically launch these challenges to protect things like water or wetlands and not just get standing and win? The example I'm thinking about is what happened with the southwest part of the Calgary Ring Road, where the EAB basically did something so rare. It not only gave them standing, but overturned the decision and said this ring road is not done in accordance with the water law. So I was just wondering how likely it is that one of those remedies would be granted successfully.
Thank you, Larry. Okay, so you referred to the Brookman case. I take it at the Environmental Appeal Board, and just to clarify, that didn't overturn the ring road or anything like that. What that case did, Brookman was a person who was deemed by the Environmental Appeal Boards to be directly affected by this decision where the developer got a permit to drain 24 wetlands in connection with the building of the Southwest Ring Road for Calgary. And he and there was another party as well were found to be directly affected. Interestingly, they weren't directly affected when they tried to contest the approval itself, but be that as it may. So how likely is it that that kind of situation might happen again? I mean, what happened was that the EAB agreed with them that they applied the wrong wetland policy. They applied the old one rather than the one that came out in 2013, and said that the approval had to be looked at in connection with a new policy, and whether that will result in a better ending for the wetlands, I'm not sure. But I think the real wonderful thing was what the minister did afterwards, because all of these decisions of the EAB are recommendations only, and then the minister either approves or disapproves. But in the history of the EAB, it's usually pretty rubber stamped, and there's no reasons given. But this time, our minister, Environment and Parks, modified the EAB decision to make it stronger, really, and to say, not only did the 2013 policy apply, but he said, you can't touch this one main wetland. What's it called? Beaver Pond, I think. That wetland is going to be protected, and that this development cannot hurt that wetland, and that all the other and the impacts on a few other wetlands, had to be sort of, you couldn't impact them more, or if you did, it had to be strictly with the director's conditions. So I think one of the most remarkable things about that case was is that the minister not only changed the EAB's decision, but gave reasons, and big, long, substantive reasons. And that's where she said that the wetland policy is law. I mean, she said it's binding on administrators. So that's very interesting. But how often does that happen? I think overall, if you look at EAB decisions, I don't know if I have any empirical research on this, but the ANGO groups, or the more environmentally minded people, lose more than they win. I know, would you agree generally?
Oh, absolutely.
Absolutely, okay. So it's really, that's why the role of these decision makers is so important, whether it's a tribunal or the courts. Because if you have, someone who's more environmentally sympathetic, because a lot of these things can go either way, and I don't know how, what's the right approach to make it go the way that leads to more environmental protection.
Just a comment for Dave. One of the slides, I think you had identified the government of Alberta claiming ownership over water.
Well, they do own it. That's, well,
I believe
I'll let
that,
you finish your point.
I believe that in the Natural Transfer of Resources 1945 amendment, they identify previous agreements, previous arrangements, such as Treaty 7 and other hydro agreements that were entered into, namely the Horseshoe Dam, Kananaskis Dam, Ghost Reservoir, that were all subject to, or prior to 1945. So just to clarify that that 45 amendment is subject to other agreements that include agreements between government and the Stoney.
Yeah, thank you. That's an important correction. Yes.
I have a question, David. And it goes to this whole question of using market-based instruments to address environmental values. Now,
Yeah.
I think you said the idea is to use the price mechanism to influence behavior. To have a price mechanism works, you need a market, and you actually need, unless you're being dirigiste and you just say, this is the price. But
Right.
normally, to be efficient, you need a market. The problem comes with non-pecuniary values that are not easily priced. For example, traditional Aboriginal values, perhaps, the endowment effect. There's all sorts of them. But the interesting thing about these values is they're typically the ones we worry about in environmental
Yes.
considerations. So there's something almost paradoxical about using market-based instruments in a situation where we're trying to get at those values that really don't have much of a market. And I wonder if you could speak to that.
Yes, I'm not sure I can say anything too intelligent about it. I mean, you certainly identified a dilemma that and a lot of people find the whole idea of MBI is actually quite offensive for that reason, that at some level it involves taking intrinsic values and converting them to market values, or as some people refer to it as commodification. I would say that I think that the intention behind that is that even though maybe the crass mechanisms of the market may be required, that the outcome at the end of the day may be better than standing on principle on intrinsic values. But that valuation process, it depends very much, as I'm sure you know, on the nature of the particular resource and the human relationship with it, how that valuation may be done, how it may be captured. But it's definitely an area that's fraught with difficulty and sensitivity. Yeah.
Thank you. I have maybe a slightly random question, but I was wondering if the panel could potentially speak to the Alberta Agriculture and Pest Acts and the impact that it has on municipalities for those wildlife that is listed as nuisance species and their ability to manage them.
The Agricultural Pests Act, is that what you said? Oh. I don't, I'll just say a couple of things. I don't really have much to say, but agriculture has always been really favored in the province in the sense that it's not as regulated as other industries. Non-point source pollution from pesticides and and herbicides isn't very well regulated. Agricultural Pests Act, of course, gives agricultural interests lots of rights with respect to dealing with pests. How does that relate to species at risk? Is that your question?
No, it's more to do with municipalities and as landowners, and there's the nuisance list of wildlife, like coyotes, other things, and the powers of then the landowner to manage those species on their land.
Okay, well, that would bring into certain provisions in the Municipal Government Act that make at least certain of the provincial legislation have priority over municipal bylaws and municipal authorities. There's a lot of specific acts mentioned, but I can't remember at this moment. It's not like every municipal act, provincial act, has priority over municipal decisions. And the Agricultural Pests Act, I don't think is specifically mentioned. And there are cases, the Spray Tech case from many years ago was a Quebec case where the Supreme Court of Canada said it was okay for municipalities to have stricter rules than the province or the federal government. But they can't really be inconsistent with those rules. So that would be an issue that might arise in this case.
Should they make this the final question? So, unless there's a burning one online.
We can give her final answers.
Thank you. I'm not a lawyer, so I'll try to frame this in a way that I hope makes sense. I've become aware of a situation, and Bill Snow kind of alluded to this, on one of the hydroelectric reservoirs west of here. Over the past decade, there's been a large escalation in motor vehicle traffic on the ice in the winter, to the point where I have counted over 175 vehicles on a Sunday afternoon of all descriptions. And it just occurred to me when I think Bill was alluding to the amendment to the Natural Resources Transfer Act that may question the ownership of the water between the nation and the province. And I'm wondering if in all of this discussion about easements and ways of protecting habitat and possibly protecting water, if there's possibly some mechanism that would, assuming everybody thinks that motor vehicles on upstream water supplies is repugnant, is there a mechanism by which to possibly get those vehicles off the water or ice? Hope that makes sense.
Okay. Well, government could just regulate it, enforce. There are laws out there in the Public Lands Act. Of course, the province, subject to, depending upon who owns that, of course. If it's provincially owned water and ice, then they could be regulated provincially. If it's federally owned, or then it would have to be regulated federally. But that one way to do it just be to more effectively regulate it. If it's provincial, for example, there are certain parts of the Public Lands Act that prohibit destruction or impairment of public land. That's Public Land and Water Act as well. And there's
in that particular case, as
Yeah.
you and I discussed
Yeah.
before, the bed and shores is
Right.
not public. It's an exception to that. So does the Public Lands Act apply in a case where the land was owned in fee simple title prior to the NRTA,
Yeah.
and in this case a power
Yeah.
company owns
Yeah,
title to the land.
That's very interesting. It was an interesting exception because bed and shores of water bodies and rivers are normally owned by the province if it's provincial land, or the federal government if it's federal. But a title, I mean, it could be specifically granted, and you're saying in this case it was specifically granted, but still the water is going to be owned by the government. So there could be prohibitions with respect to the ice.
Okay, we'll take one final question online and then wrap it up.
Okay, this is a question from an Ontario viewer. He's asking about a template for conservation easement agreements developed in Ontario by the Ontario Land Trust Alliance. And he was wondering if there are any other similar templates in other provinces or...
I believe, and I'll allow it, many of the land trusts have developed their own templates, and to some extent they have exchanged those, either advertently or inadvertently, and so I think there are certain sort of norms that are expected, but that's been an informal process. And one of the comments that I have heard from those that are familiar with those templates is that they may be far more complicated than they have to be, and that there's a perception in some areas, like in the agricultural community, that conservation easements are incredibly complicated instruments, and that may be far more than they need be.